First board meeting. I'm excited. All right, we are recording. So kick us off here. Good afternoon. And welcome to the Ann Arbor DDA September 2021 board meeting. My name is Tyler Kinley and I'm the DDA board chair. Given this is a virtual meeting, I'll go over details for the meeting. It is important to note that the DDA is allowed to continue holding virtual meetings as authorized under the amended Open Meetings Act, extending the authority for public bodies to conduct electronic virtual meetings through December 31st, 21, due to the local state of emergency declared by the Washtenaw County Board of Commissioners as of March 17th, 21, and to continue through December 31st, 21, due to the sustained presence of COVID-19. DDA board and staff will participate by video and audio and are doing so from their homes or offices in Michigan. DDA staff members participating today are Maura Thompson, Sarah McCallum, Jada Hallbrook, and Kelly Graves. Thank you to members of the public who are joining us today. Your microphone will be muted during the meeting. Time has been set aside at the end of the meeting for public comment. The chat function is enabled for use by DDA board members during the meeting to indicate you wish to speak, and Kelly can help keep track of this. We ask that DDA members and staff identify yourself before speaking. When not speaking, please mute your microphone. A reminder that during roll call, each member of the board must state they are attending the meeting remotely and their physical location at city, county, city, township, or village and state where they're located. Maura, if you will please help out with a roll call.
Sure. Micah Bartelme. Alex Deek.
Here, participating remotely via Zoom, City of Ann Arbor, County of Washtenaw, State of Michigan.
John Fournier. Jihei Kim.
Here, joining via Zoom, Ann Arbor, Washtenaw County.
Tyler Kinley.
Present, joining via Zoom, Ann Arbor, Michigan.
Marie Clough. Jess Lita. Molly McFarland. Darren McKinnon.
Present, City of Ann Arbor.
Jonathan Massey.
Present, City of Ann Arbor.
And Rishi Narayan.
All right, thanks, Maura.
You're welcome.
This is my first motion. I'm excited. May I have a motion and a second to approve the board meeting agenda?
So moved. This is Jonathan.
Second, Darren.
All right, hearing none. All those in favor say aye. A. All those opposed say nay. Didn't hear a lot. I'm guessing we can approve the meeting, correct, Kelly?
Yes.
All right. I believe asking beforehand that we may have had someone sign up ahead of time to speak. Is that correct, Kelly?
Yes, we had Alan Haber. Alan, are you with us? I don't see him in the participants, Tyler.
All right, we'll give him a little bit of time here. Alan, if you're with us, just chime in. All right. If he comes in a bit, maybe he can chime in and speak at the end. We will move ahead. The next is reports from city boards and commission. The Downtown Area Citizens Advisory Council did not meet last night, so there is no report. The next is DDA members communications. Please state your name before you speak. Do we have any DDA board member communications? Hearing none, we'll move ahead, thanks. I would like to turn it over to Maura for the executive director report. Maura.
Thank you, Tyler. Yeah, I just have a few things. First, as many of you probably know, two-way traffic has been restored on First and Ashley, and the two-way protected bike lane on First is complete. However, there is still additional work being done in that project area, so the contractor remains on site and is finishing up. The Division Street Bikeway and the enhancements on William Street will begin, we anticipate, at the end of this month. As a reminder, the Division Street Bikeway is a two-way protected bikeway on the east side of Division from Packard to Catherine. And on William Street, we will be removing the delineators and replacing those with a curved buffer zone. And we'll also be doing some intersection improvements at 5th and at Division. The 5th and William surface parking lot, otherwise known as the old Y lot, as of today is now operating as an hourly lot. So you will find metered spaces in there, mainly 4-hour spots, and there are also a few 10-hour spots. And finally, the 5th and Detroit project has won a merit award from the Michigan Association of Landscape Architects. So we're very proud of this. A shout out to our capital projects manager, Amber Miller, and the design team at Smith Group for all the incredible work they did on that really transformative project. And that is all I have.
Well, that's fantastic. Congrats to us, to them. That's really good to hear.
Yep.
Thanks, Maura. Next on the agenda are the DDA subcommittee reports. The committees did not meet in August, and so there are no reports. We are flying. The dates for the next committee meetings dates are noted on the agenda and also posted on the DDA and city websites. Since the committees didn't meet.
Tyler, I'm
Yeah.
sorry.
Yep.
Before we go, could we do the July minutes? Get those-
Oh, look at me. That's why we're flying so fast. I would like to now ask for a motion and a second to approve the July minutes. Are there any corrections to make?
We have a motion and a second.
Yep, just going right for it. Hearing
So
none.
moved.
Do we have a motion and a second?
So moved.
Second.
Perfect. Any corrections to make? I didn't hear any. Hearing none, all those in favor say aye.
Aye.
All those opposed say nay. All right, hearing none, the minutes are approved. Going back to what I jumped ahead to, subcommittee reports didn't meet, no reports. The dates are set on the DDA and city websites for the next meetings. Since they didn't meet, we don't have any items of business to conduct at the board meeting, and we decided to use this time as an educational opportunity for our board and for anybody who's decided to chime in or pop in and listen. So the remainder of today's meeting will be a board training session conducted by the Michigan Municipal League, as stated on the MML site. The Michigan Municipal League is dedicated to making Michigan's communities better by thoughtfully innovating programs, energetically connecting ideas and people, actively serving members with resources and services, and passionately inspiring positive change for Michigan's greatest centers of potential, its communities. We have members from the MML with us today to provide a condensed version of their Everything Meetings virtual session. This will cover board member roles and responsibilities, FOIA or Freedom of Information Act, OMA or the Open Meetings Act, and parliamentary procedures. To introduce our presenters, we have with us Christopher Johnson, who serves as the League's general counsel. He came to the League from the law firm of Johnson, Rosati, Schultz, and Jopik, where he was a founding partner. For over 30 years, Chris has been active in the defense of municipalities in civil litigation throughout the state of Michigan. He maintains specialties in the fields of municipal law, school law, legislation, liability, and insurance defense. He is admitted to all state and federal courts in the state of Michigan, as well as the United States Sixth Circuit Court of Appeals and the U.S. Supreme Court. He is a member of the Michigan Association of Chiefs of Police and has served as a member of the state of Michigan's Emergency Planning and Community Right to Know Commission from 2001 through 2007. He has been an active member of several league legislative committees for years. In addition, he has served as general counsel in a number of nonprofit capacities in Michigan. He is a seasoned presenter and a graduate of Michigan State University College of Law, formerly Detroit College of Law, and the University of Michigan. He's also served as the mayor of Northville from 1987 to 2015 and was awarded the Citizen of the Year by Northville Chamber of Commerce in 2015. He served on the Northville Board of Education from 1976 to 1987. And in 2010, he was named top lawyer by Our Magazine and D-Business, Southeast Michigan's Journal for Business. So we're excited to have Chris with us. And our other presenter is Eleanor, or Coco, as she goes by, Seward, professional registered parliamentarian. She serves as the parliamentarian for a variety of nonprofit organizations. Coco is a trainer for the Michigan Municipal League in Parliamentary Procedure and served 2 terms as the mayor of Birmingham. Coco has a master's degree in dispute resolution from Wayne State University and uses those skills primarily in the area of resolving public disputes. Chris and Coco, we really thank both of you for being with us today. I will turn it over to you to begin your presentation.
Very good. Let's see if I can get my screen shared properly. And there we are. Good afternoon. One of the most important things I believe in terms of having a successful local government is to know your role and to know where you fit in the process of government. It will really help your DDA board know what to do, when to do it, and how to do it. The interesting thing that we have right now is that your board has a very detailed set of bylaws for the Downtown Development Authority. And it's the controlling document for what you guys are going to be doing in the future. So I really think that that's an important concept. If you haven't read your bylaws in detail yet, please get them out and please read them, because that will go a long way in making sure you know what your role is. As the governing board for the DDA, you have to recognize that your job is a policy-making body. In conjunction with the city council, you're responsible for long-term and short-term goal setting, as well as adopting a budget and any capital improvement plan. Now, why is that important? Well, you might have the greatest idea and want to accomplish something like fixing the damn roads. But if you only put $1.98 in your budget to fix the damn roads, guess what? You're not going to pay very much. You're not going to fix very many roads. So it's always important to align your budget and capital improvement plan with what the goals and objectives of the board are. Now, it's very important that you also understand that you can only act as a body, and you act as a body through your motions and your resolutions. You are individual members of a board, but you do not have the right to direct staff or interfere with the day-to-day operations of the DDA. You're just one member of the board. And it's important to recognize that a majority of the board is necessary to provide direction to the administration. Now, the presiding officer, in your case, the chair, has a number of important responsibilities. First is to acknowledge the members that wish to speak. Second is to be courteous to members of the council and to the public. Whether you know it or not, the presiding officer's tone And friendliness or unfriendliness or attitude really becomes part of the culture of the whole board. And being fair and enforcing rules that the board has is important for the presiding officer. Let's say I really like Sam, but I don't like Dave. And I'm going to let Sam talk for 20 minutes, and I'm only going to limit Dave to a minute and a half. Guess what? Your public will notice that. Your public will not be happy with you, and it will be very obvious how unfair that situation is going to be. And likewise, it's also important to enforce the public comment rules fairly. Once again, you might like Dave and not like Sam, but guess what? If you're being obvious in terms of favoring one side or another, as a presiding officer, you'll have a real problem on your hands in a very short amount of time. It's important to recognize what public comment is. And public comment is not the situation that they have in the House of Commons where it's question the Prime Minister hour. This is a section where the public gets to comment on issues that relate to the DDA. So maybe somebody has a question like, when does this particular program start? And the answer is real quick and obvious. You could say, hell, that program starts on May 1st, and just take it at that. But there's no real obligation to engage in debate or answer questions that are going to take up a lot of time. Resisting debate among the public during public comment section can be something as simple as your comments are noted and thank you. And again, be courteous about it. Some people like to get up and think that they're Perry Mason and going to really pound, somebody into submission. That's not what public comment is for. It's to allow a person to let you know what they think of your performance. The next thing I want you to consider very seriously is the kind and content of your communication with the administrator. What information do you really need? Is it regarding the critical infrastructure of the DDA? Is it your budget priorities, or where you buy your pencils? I mean, quite frankly, where you buy your pencils should be on the last part of any list of what you need to know. But you do need to know what your budget priorities are, because you need to set those budget priorities. And that'll make a difference for your community. And then if the information is important to you and you've requested it from the administration, it should be important to all of the board. So especially while I was mayor, I made sure that any council member that asked a question through the administration, that information was provided to all the council members so that we don't play gotcha. Because if you play gotcha at board meetings, you're not building a healthy personal relationship with your fellow board members or your staff members. You're poisoning the well on a relationship that you will need to get your particular ideas through. As I mentioned before, you need to act as a body. So that really means you need to win over your fellow board members to accomplish your own personal goals. And quite frankly, if you just insulted a fellow board member, they'll remember that. They won't cooperate with you, and you'll be stuck in a role of dysfunction, which is kind of what we have going on in Washington right now. You need to extend courtesies to each other. You must give respect to receive respect, and that's important. I often compare this to a skit I saw on Saturday Night Live where Dan Aykroyd turns around to Jane Curtin and says, "Jane, you ignorant slut." Well, guess what? You do something like that at a board meeting, and you will never get Jane's vote in the future again. It's just not going to happen. And whatever you had planned on, whatever great idea that you had as a board member is going to stop right there. The most important things about ethics, and you have a really, really good section regarding ethics and conflict of interest in your bylaws. I've read them and I really like them, is in your conflicts of interest section and ethics. That's section 9 of your bylaws, and that's a very important set of documents. The Institute for Local Government has 4 tenets for ethical conduct that are really summarized in all your bylaws. And the first is do not benefit financially from the position. It may seem obvious to some people, but it's not obvious to other persons. You should not benefit from the position, and you should not receive special benefits by virtue of the position. Let me give you an example. In my community, I live on Main Street, and Main Street is a street where the fire station is in. And so it's one of the first streets that gets plowed when a snowstorm happens in Northville. What's kind of interesting about that was there's a lot of people that say, oh, it was the mayor's street that was first to get plowed. No, it wasn't the first street to get plowed for that reason. It was because the fire station is on Main Street. And by the way, as a side note, my driveway was actually off of West Street, which was one of the last streets to get plowed in Northville. So, you know, just don't benefit by virtue of the position. Don't go into some restaurant and assume that, you know, the restaurant should accommodate you and give you a free meal. That's a special benefit, and you shouldn't be going there. The next item is not to be secretive in your decision-making process. The more transparent you are about what you're doing, the more you'll be able to defend a situation or whatever as you proceed along with the public. And finally, don't let favoritism or bias cloud your decision-making. We all have favorites, we all have biases, but if you allow that to interfere with your decision-making, you're likely to make the wrong call at the wrong time. It's very important that you expand your horizons a little bit and listen to your fellow board members, listen to the public, listen to those that are bringing you ideas. And they might not have been what you thought of originally, but there was nothing more eye-opening than having somebody at a city council meeting in Northville pop up with, hey, did you ever think about this? No, we hadn't thought about that. Guess what? You're on the committee. So you can find out a lot of things if you expand your horizons a bit. And my favorite quote on ethics is from Potter Stewart, a former United States Supreme Court Justice. And what you have the right to do does not equal what is right to do. And he was a very wise man in that sort of situation. Ethics is also important with respect to social media. While social media is a good tool to communicate with the public, great care needs to be taken that an individual board member does not represent their personal views as the view of the board. You may or may not disagree with the position that's ultimately decided by the board, but you do not have the right to go on social media and say, the board said X, when the board actually said Y. That's very important to keep that difference. And again, you're one member of the board. You're not the board. So don't represent your position as being that of the DDA unless the DDA has adopted your position. Next thing we need to do is get into some of the Michigan Sunshine Laws, which you are subject to. And there's 2 main acts, and we're going to start with the Freedom of Information Act. This happened because of a scandal, and that was the Watergate scandal that happened in 1974, that ultimately resulted in the resignation of President Nixon. There was a response in Michigan, and the Michigan legislature enacted 2 laws, the Freedom of Information Act in 1976 and the Open Meetings Act in 1976. And both were effective in 1977. And if you were listening to Tyler's introduction, you'll notice that I was actually on the Northville Board of Education when these laws went into effect. And by the way, it changed everything. Instead of going to the bar and deciding what would happen before a meeting, actual business transactions occurred at the public meeting instead of, in somebody's private residence. The policy of the Freedom of Information Act is stated quite succinctly in the Act, and it's that persons are entitled to full and complete information regarding the affairs of government and the official acts of those that represent them as public officials or public employees. And the courts are very, very, very consistent in this. And the basic thing is the people shall be informed so that they may fully participate in the democratic process. Case after case after case has the same view. So what must the city provide? A public record. And that's described in the Act itself as a writing, which is prepared, owned, used, and in the possession of, or retained by a public body in the performance of their official function from the time that it is created. And what is a writing? That's also found in the statute. And remember, this was 1976 that this language was written. It means handwriting, typewriting, printing, etc. But the very last section of the description is, or other means of recording or retaining meaningful content. That's very important. So what does it mean today? Well, it means typical writing a paper, but it now includes email, text, voicemails, and even entries in a mobile data terminal, such as you find in a police vehicle. So the basic requirements of FOIA is that the DDA will appoint a FOIA coordinator, and that's going to be the person that's going to be responding formally to the FOIA request. The FOIA coordinator may be coming to you specifically for information depending on what the request is. Cooperate with that person as quickly as you can because they're under very, very tight timelines under the Freedom of Information Act. Back in 1976, this was science fiction. There was no such thing as laptop computers. There was no such thing as desktop computers. The computers that were being used in government were huge in terms of taking up space. Another thing that was science fiction was your smartphone. 1976, this stuff didn't exist. It was a comic book idea in a Dick Tracy magazine, and if you're too young to know who Dick Tracy is, you can Google that and find out. But the instant communication that you have now didn't exist in 1976. So in 1976, there was nothing like email, text messaging, or social media. And we now know that email clearly falls within the definition of writing, as well as texting and voicemail too. So if the information is only stored on your personal computer or a computer provided to you by the city or your own personal smartphone, a circuit court judge may someday say, turn that item over to us so that we can clone your hard drive and find out what you've been saying about particular issues. A very significant case involving the Freedom of Information Act is called Howell Education Association versus the Howell Board of Education. And this case is important for two specific reasons. The first is a new concept known as purely personal communication. In that case, the court held that a teacher's request to a spouse to pick up milk or bread at the store because they weren't going to have time to get to the store before they were getting home was purely personal communication. It had nothing to do with the operation of the school district. And for that reason, it didn't need to be turned over. But probably the more important takeaway from the case is that the content of the message is more important than where the message is stored. So if it directly relates to your business as a DDA member or any other city business, that message is FOIA-able. A member of the public can get that, as well as the fact that the only place it's stored on is your personal smartphone. A judge might order you to cough it up. So even though it's your own computer or your own smartphone, you may want to be very careful about what business you do, city business you do on your own personal equipment. We have a lot of additional FOIA resource materials. There's a FOIA resource packet at our website, which is www.mml.org. We also have one-pager pluses regarding FOIA. There's the way to get at that. And finally, if you're really into knowing what the law is, there's a very excellent publication done by ICL, which is the Institute for Continuing Legal Education, on the Michigan municipal law. And there's a whole chapter devoted to sunshine laws and local government. Now, the next part is regarding the Open Meetings Act, also known as the OMA. The actual language of this statute is that a public body, which includes a board, commission, committee, and subcommittee, and most people seem to forget about that, and they use the idea of, well, we don't have a quorum of this committee, so we don't have to post it as a public meeting. Wrong. The courts have gone to extreme lengths to say that is a meeting that must be open to the public. The policy of the act, again, is to strengthen the right of all Michigan citizens to know what's going on in the government by conducting all or most of the business at an open meeting. And the judicial view is consistent here as well. For example, we do not countenance the use of strained legalisms or evasions to undermine the intent of the OMA to promote open and responsible government. That's the kind of thing that a court will slap communities down on with. They don't want you messing around with the Open Meetings Act. Conduct your business in public. So the basic requirements of the Open Meetings Act is, unless there's a specific statutory exception, all meetings of a public body shall be open to the public. And all decisions of a public body must be made at a meeting open to the public. So you might be able to discuss or deliberate toward a decision in a closed session, but you have to make the actual decision at the open meeting. So again, unless you are deliberating on one of the statutory exceptions, you must meet in open session. So the Open Meetings Act applies if we're talking about a public body, which you are, including your committees and subcommittees, meeting with a quorum present or a constructive quorum, convene for the purpose of deliberating toward or rendering a decision on something by which a vote of the public body is required to effectuate public policy. These are all important concepts. And a meeting is, deliberation has been defined by the courts, meaning any discussion toward a decision. It's not actually defined in the Open Meetings Act, but there are court cases that are very important here. The act of carefully considering issues and options before making a decision. So let's throw all the ideas out on the table and let's narrow down the options we want to select. That's a deliberation, and that must be done in an open session. Again, unless one of the specific statutory exceptions exists. And we've had some attempts by public bodies to divide themselves into multiple subcommittees and then meet in private. There's a very famous case in the University of Michigan that, the Board of Regents broke up into little subcommittees, and then one regent went around and talked to all of them. The court held that was a constructive quorum, and that would violate the Open Meetings Act. So let's talk about what the basic requirements are of the Open Meetings Act. First is notice. Within 10 days of your first meeting of the new calendar or fiscal year, that's your choice which you want to choose, you must post your regular meeting schedule. But if there's a change in that schedule, it must be posted within 3 days. And if you have a website, you must post those notices on the website as well. Special meetings and rescheduled regular meetings require at least 18 hours notice. And believe me, judges know how to count up to 18. I've had situations where a judge is yelling at me, "Mr. Johnson, don't you know how to count to 18? Didn't you advise your clients?" Well, I did, Judge, but they weren't paying attention. And finally, minutes must be kept of all meetings. Now, minutes are not court transcripts. Court transcripts is where you get a court reporter in to record every single word that's stated in a courtroom. Well, every single item that's stated during a public meeting isn't necessarily entitled to be in the minutes. What you do need in the minutes are the date, the time, the place, the members present and all the members absent, and a record of any decision made. And by the way, if you go into a closed session, the actual purpose or purposes of the closed session and all roll call votes that are taken. That has to be in the minutes. It doesn't need to say, Chris Johnson said X, Sam Davis said Y, and Mary Conway said L. That's not required in the minutes. What is required is what the motions were, what the votes on the motions were, and what actions were followed up on. One of the basic requirements of the Open Meetings Act is public comment. So citizens have the right to address the meeting and to tape or video record the meeting. That is the right given in the OMA. Now, the public body may establish reasonable rules for that. You can have public comment at various sections of the meeting, at various points in the meeting, depending on the rule you want to establish. It could be at the beginning of the meeting, it could be at the end of the meeting, it could be at the time you're discussing a particular agenda item. I've seen it all different ways. As a practical matter, as a political matter, you may want to look carefully at only allowing public comment at the end of a meeting, because the citizen has not had a chance to give you input before you make the decision. And that gets people very angry. And if you have an angry public, you won't be around a whole lot, I've found. The next thing that's important to remember is that a person can only be removed from a meeting due to a breach of peace committed at that meeting. So Chris Johnson is being an idiot and disrupts your DDA meeting. I can be removed from the meeting for that meeting, but I might want to attend a subsequent meeting of the DDA. You cannot prevent me from being at the subsequent meeting. Now, if I'm an idiot again, and I jump up and down and disrupt the second meeting, I can be removed again from the meeting, and the third time and the fourth time. But I have not seen any circuit judge in the state of Michigan since 1977, when this act went into effect, give a permanent injunction against a citizen from attending a meeting. It is just not going to happen. As I mentioned before, you can limit the place of where public comment happens and restrict the amount of time an individual may speak. However, you cannot set a total limit of time on the public comment section. So while I was in a situation where I would look out in our audience, and if we had 50 people show up at a meeting in Northville, I knew that there's something going on. We did something that got people upset. So, you know, you couldn't limit those 50 people from talking and taking up the 2, 3, 4, 5 minutes that were allowed each person. And oh, by the way, that doesn't mean that citizen A can cede their time to citizen B. That's not what we're talking about for public comment. Those are rules that the Congress has. But you can use certain techniques I've found where if you listen to the basic same comment being made for the third, fourth, or fifth time, the chair can often use this technique where you say, Mr. Smith, you've said A, B, C, and D. Is that correct? And Mr. Smith will generally say yes, as long as you're quoting them accurately. And one of the things I've noticed is then you look at the audience and who else agrees with Mr. Smith? Raise your hand. And oftentimes, most of the people will raise their hand. Thank you. Then again, be fair. So how many of you disagree with Mr. Smith? Please raise your hand. And the group will probably tell you that way what their feeling is. And everybody now has participated. Everybody has told the DDA what they thought of a particular issue and not have to have all 50 people go up to the microphone and say, this is, my position over and over and over again. But if they want to get up in front of the board and make their comment, they do have the right to do that. So we were talking about there's 6 reasons in the statute for allowing closed sessions. So calling a closed session and going into the closed session, there first has to be an open meeting. A motion has to be made and seconded, and then an adoption of the motion to go into a closed session. So a simple majority of the board is required to go into closed session for discipline, personnel evaluation of an official or an employee, or 2, for collective bargaining, if you are responsible for bargaining on any a union contract. There are 4 other exceptions to the Open Meetings Act. Requires a 2/3 roll call vote. I always recommend a roll call vote. It's a good strategy, even in the majority vote situation, because it makes it clear who voted and how they voted. The roll call vote and the purpose for calling the closed session are entered into the minutes of the open meeting. And please be specific as to the section of the act that you're going into closed session for. We're going into closed session to review the collective bargaining agreement. Just make sure that's clear and cite the appropriate section of the statute. Your attorney's office can probably help you craft those motions as you need to go along. Now, I'm going to handle these in the order of the statute itself rather than my own personal opinion of how important these are. They're not in any order other than the order of the statute. So the first reason you can go into closed session is if requested by the named person to consider dismissal, suspension, disciplining, or just a periodic personnel evaluation of a public officer or employee. And I recommend, this is just a recommendation, but I recommend getting the request in writing so that if you ever need to show it to a judge, I, John Smith, request to go into closed session, etc., you'll have it there. The second reason to go in closed session is for strategy and negotiation session connected with the collective bargaining agreement, if requested by either negotiating party. And I recommend that you do it in close proximity to negotiations. You can strategize and build consensus among board members, but you probably shouldn't be doing that 4 years prior to the expiration of a current collective bargaining agreement. The third reason that's permitted is to consider the purchase or lease of real property up until the time of an option to purchase that property or the lease of that property. But please note that sale of public property is not covered under this exception. The fourth reason is to consult with an attorney regarding trial or settlement strategy in connection with specific pending litigation. Smith versus the DDA, where somebody's actually sued the DDA in some dispute that you may have with them. it's important that pending means something that's actually filed in court. It doesn't mean somebody who stands up in the back of the room and says, "I'll sue you." That's not what we're talking about. We're talking about Smith versus the DDA or something versus Ann Arbor. It's got to be very specific in that respect. The next section is to consider contents of an application for employment or appointment to a public office if the candidate requests that the application remain confidential. The reason there is kind of obvious. There are some communities out there that if their administrator was even considering taking another job, they'd just fire them. So it's to protect that individual. However, if you're doing interviews for employment or appointment to the public office, the interview must take place in an open meeting. And the final section is to consider material that's exempt from discussion or disclosure by state or federal statute, for example, under FOIA. So an example might be a written opinion by your municipal attorney, and due to the attorney-client privilege under FOIA, just make sure that your discussion is within the four corners of that legal opinion. An appraisal for an amount of time that it's exempted under FOIA. You are interested in purchasing property at the corner of Main Street and Elm Street. Well, if you do that, the other side would know what the appraised value is, and that becomes a floor rather than the ceiling as to what the city would need to pony up before obtaining that property. And finally, security plans, if they're exempt under the Freedom of Information Act, how you would respond to a bank robbery. The bad guys would really like to know how that would be done and avoid the police entirely. So closed session requires a separate set of minutes. And again, these should be done by the designated clerk or designated secretary to take those minutes. Those minutes may only be disclosed if required by a court order. That's important. Only be disclosed if required by a court order. You don't have the opportunity to disclose those minutes in and of yourself. The public body may meet in closed session to discuss those minutes if you have some dispute about them. I strongly recommend minimal minutes for a closed session. Who was there? What time the meeting started? What the purpose of the meeting was? We were going to discuss the collective bargaining agreement and the fact that the meeting ended at a certain time. The minutes, the closed session minutes may be destroyed 1 year and 1 day after approval of the minutes at a regular meeting at which the closed session was approved. Remember, those minutes and those sessions are confidential. So when a member reveals what happened or what was said in the closed session, the Attorney General has said that the minutes of a disclosure of minutes of a closed session could result in criminal prosecution and civil penalties under the Open Meetings Act. And many municipal attorneys argue that the same goes for information that was discussed. While the Attorney General was only asked in that situation about the minutes, it's clear that the damage that's done by a member disclosing the fact that they're interested in the property at Main Street and Elm Street actually will result in a higher cost to the local body and hurts the taxpayers as a result of that. So we have a real problem with the Open Meetings Act and current technology. I call it the OMA versus the iPhone. There's a real technology trap now that exists that the legislature hasn't really dealt with. As I mentioned before, deliberating can be done electronically. Both emails and texting can be a violation of the Open Meetings Act. And let me give you an example. A city council member comes up with a great idea. The council member shares this idea with the entire council. Then all the other members of the council start replying via the reply all feature of the email system. See the problem? Social media can also fall into this category. Council member one of a 5-person council takes to her Facebook page to champion a great new idea. Assume the idea, again, relates to her role as a council member. Council member two does not like the great new idea and replies with a post of her own. 2 days later, council member three agrees with board member one and posts a reply. You see the problem? The problem is that in those examples, none of the procedural requirements of the Open Meetings Act are followed. In business, we're getting trained to hit reply all so that everybody understands where everybody else's position is and contributes their ideas that way. But the problem with hitting reply all is that you don't follow the requirements of the Open Meetings Act. So what happens if you violate the Open Meetings Act? The action in question may be invalidated. The Attorney General's office, a county prosecutor, or any person, which includes media, may bring a civil action in civil court to challenge the validity of the action taken by the DDA. And again, as per the Attorney General, a public official who disseminates closed session minutes risks criminal prosecution and civil penalties. The Open Meetings Act also provides for criminal misdemeanor penalties against any public official who intentionally violates the act, specifically 90 days and $1,000 for the first offense, and up to a year and $2,000 for the second and subsequent violations. That's a real penalty, folks. And at a recent press conference given by our current Attorney General, she was asked, why should we worry about the Open Meetings Act? Nobody follows it anyway. She made the statement that if you bring that kind of serious, flagrant violations of the Open Meetings Act to my attention, we're going to prosecute. Now we've got a situation right now, and we started the meeting off as a virtual meeting, and we're continuing it as a virtual meeting. The governor and the legislature debated for some time about the powers of the governor, which included the decision to allow virtual meetings of a public body. The Supreme Court did issue 2 significant decisions on the governor's power, which resulted in changes to the Open Meetings Act. The decisions were regarding the emergency powers of the Governor's Act, which had been in place since 1946, and the Emergency Management Act, which was adopted in 1976. The court ruled that the 1976 Emergency Management Act requires the governor to receive the consent of the legislature to extend any emergency beyond 28 days. And the court also ruled that the Emergency Powers of the Governor's Act was unconstitutional because it gave so much legislative powers to the governor. And by the way, that act has since been repealed by the legislature. So the current version of the Open Meetings Act permits virtual meetings for a member to participate remotely if that member has a health concern, or in a situation where there's a properly called state of emergency in the community. And these types of virtual meetings are now allowed until December 31, 2021. It's something that the Municipal League is tracking pretty closely because it appears that the pandemic is not over yet, much to the consternation of all of us who would rather, be at a public meeting safely rather than be home doing our work from our computer. I want to give you my first rule of public service. When you got involved with the DDA, it was for good reasons. You wanted to serve your community, but it's not fun if you're sitting in jail. And violating the Open Meetings Act can result in a jail sentence. That's something you don't need, don't want, and it's not very fun. We have a lot of Open Meetings Act resource materials, again, on our webpage, mml.org, that very detailed Michigan Municipal Law Chapter on sunshine laws, as well as a handbook issued by the Attorney General's Office, who is now Dana Nessel, not Bill Schuette. With that, Mr. Chairman, if you have any items you would like me to discuss or questions, I can handle those, or we can start with Coco's presentation and handle all questions at the end.
Well, Chris, thank you. That was, we packed a lot of information into under an hour there. It's, I think that was incredibly beneficial. Do any members of the board have any questions for Chris? I'm seeing some cameras pop up here. We'll sort of open the floor. I think all of that was really, really fruitful. There's a lot of stuff that I didn't know the full details on. It's really it's quite interesting to know a lot of the background as well. Alex, Jonathan, Jihei, Darren, any staff, do we have any questions for Chris before we move on to Coco?
No.
I don't have further questions. I wanted to thank you, Chris, for that clear walkthrough.
I think Alex is talking. Unfortunately, you're muted.
Yeah, I would just second what Jonathan said. That was really helpful, especially some of the clarity with regard to going into closed session. I think a direction for our board on how we do that in relation to the exemptions under OMA. And I thought that was really helpful. So thank you.
You're welcome.
Yeah, thanks, Chris. We'll move ahead here. Coco, we'll give you the floor. Chris, thank you again. And Coco, look forward to hearing from you. Coco, I believe you are muted. You might want to just backtrack a sec and pop back in. I'm sure.
There we go. No, there we go.
Here you are.
Sorry about that. I think "you are muted" is the phrase that we'll all live with for the next year, for the past year. Effective meetings using parliamentary procedure. Next slide. General Henry M. Robert, who was the author of Robert's Rules, and I have the most recent edition in my hand, the 12th edition, was an American soldier, engineer, and author. In 1863, without time for preparation, he was asked to preside over a church meeting. He managed, but did not do particularly well, and pledged to learn parliamentary procedure. Next slide. He looked around to find books on parliamentary procedure, but he did not find anything for the average person to use to chair a meeting. So he knew he had to create it. What was popular at that time was Jefferson's manual, which was still used in the House today, but it was not appropriate for anything that was not a legislative body. The result of his work, first published in 1893, is now in its 12th edition, which came out last August. But those in municipal government don't have to run out and buy another copy, because anything you have is probably pretty good. There were 117 changes in the book, but none of them affect local government, and all of them are just designed to make parliamentarians dance around in happy feet. Next. The most popular standard is Robert's Rules of Order newly revised, which people use. The organization of the procedures in the book is reflective of the author's military and engineering training. And I just this morning had occasion in that meeting that I mentioned to have someone say, I couldn't possibly learn all of that. Well, actually, it's very well structured so that once you get started on it, it actually makes sense. And I do recommend to people that the book you should get is Robert's Rules of Order newly revised in brief. It's short and it has everything you need to know. And in fact, I often say that 85% of the questions I get come from only 15% of the book. And this is that 15% of the book. Next, please. There are a number of different parliamentary authorities. but Robert's rules is the most popular for organizations. Many state legislatures, including Michigan, use Mason's Manual of Legislative Procedure, which is specifically designed for state legislatures. Next. Why use parliamentary procedure? People ask, oh, we don't use parliamentary procedure. Well, what do? Well, we just make motions and vote. Well, actually, that's really all it is. It's just a way to, you already had your first motion today, and it is just a way to make motions and vote. And it's a tool that enables members to accomplish an organization's goals. It's a very recognizable format for a meeting. If you go to a meeting and somebody says, is there a motion? People generally know what you mean. It introduces motions that lead to decision-making. That is an important issue. I had a group again just last week that said that their organization is not moving forward. This is a nonprofit. It's not, nothing's happening. I asked them to send me their minutes. There was a long pause on the phone and she said, well, I think I can find some, which Chris told me something right away. When I got the minutes and she sent me 3 sets, I called her back and I said, you have no motions. She said, well, we operate by consensus. We just agree to things. I said, but nothing is actually happening. Well, she said that was true. I said, you have to make motions if you want something to actually happen. Otherwise, you're always saying, weren't we going to fill in the blank? Next, please. There's a funnel of laws that's important for you to know. And federal and state laws, city charters, corporate charters, bylaws, and in fact, Chris referenced your bylaws, which indeed give you quite a bit of advice on how to have your meeting. Rules of order, standing rules, all supersede a parliamentary authority. So don't ever let anyone shake Robert says at you and say, Robert says, because as you see at the bottom of the slide, so with each suggestion you learned today, always say, unless my organization has a rule to the contrary. And this lets me underline Chris's recommendation that you read your bylaws, because there may be things in there that are not in accordance with Roberts, and that means that the bylaws supersede Roberts. Next, please. Basic objectives of parliamentary law. And really this slide summarizes the entire book. Accomplish the objectives for which the group is organized, expedite business, ensure justice and equality to all, and maintain order. That's the whole goal of parliamentary law. Next, please. An agenda. Well, you have an agenda, and as you saw, you were going through it. It helps you remember what order to go. Sometimes organizations like to set exact times for their consideration, and they will, down the left side of an agenda, put the time they hope to, at which time they hope to accomplish something. This is acceptable if it's only for guidance. If it's noticed as a public hearing for a specific time, the time must be adhered to. But otherwise, if you just put times on your agenda, that is for guidance. And it's acceptable to be ahead or behind the time. But I do feel that in meetings where they've had problems, particularly nonprofits, with meetings running too long and not staying on track, that the times are gentle reminders to the members of where they're supposed to be. And there's almost a little cheer that goes out if they say, oh, look, we're 10 minutes ahead. Next, please. To be binding, the agenda must be adopted by the body, and the members may vote to make any changes before it's adopted by a majority vote. So if you adopt your agenda and the chair says, are there any changes to the agenda? That might include, I move to add, or I move to strike. But once it's adopted, a 2/3 vote is needed to make changes. Why is that? Majority vote to adopt, but 2/3 to change, particularly in meetings that run for a morning and an afternoon or several days, like a convention over a weekend. Once it's adopted, you know what time the vote comes for the officers. And that would have to be changed by a 2/3 vote of the rest of the assembly. So you know that if it's a convention and you decide to go golfing in the morning, you know that when you come back, the election is still at 2 o'clock. Next. A voice vote is the most common form of voting. Ayes and noes. The usual motion requires a majority vote of those present and voting. The presider should always ask for the negative vote, even if the outcome is clear. So if you say, and it's so hard on Zoom or any virtual thing on voting. Many city councils that don't usually take roll call votes have now resorted to roll call voting. Being the parliamentarian for the MML for over 25 years, I've attended a lot of council meetings and I've seen big changes that have occurred. And that is one that they are taking roll call votes, which they never did before and swear they will never do once they go back together. But it is a way to make sure that the vote is clear. We've had a couple of councils where they didn't take the roll call vote early on when we first went virtual, and the minutes did not reflect what the council felt had really happened. And they immediately went to, I recommended to them, go to roll call, and then that won't be the issue. Next, please. An abstention means to not vote at all. And you have in your conflict of interest policy clear rules of when you should and shouldn't vote. If a member has a conflict of interest, he should state that conflict when the presider states the topic and ask that his abstention be recorded in the minutes. So as soon as the chair says the next item on the agenda is the repaving of Elm Street, if there's a member who has a conflict of interest because they have a financial interest in the company that has bid, they should state that immediately, say, and I'd like that recorded in the minutes. So it's clear forever that that person was abstaining and was not involved, and then they should not speak. I just had, yesterday somebody asked me, is it necessary to leave the room? No. And does abstention mean the same thing as recuse? Yes. Next, please. A rising vote is the normal method of voting on motions requiring a 2/3 vote. It can also be used to verify a voice or hand vote. So if I took the vote and it needed 2/3, and it needed a majority, but I couldn't really hear it very well, the chair could say, I'd like to take that again by rising. So we know for sure. And the chair, and if the chair states the vote and you don't agree, and this usually happens in large bodies, 150 people or more, where the vote is not clear, and the chair says all those in favor say aye, those opposed say no, the ayes have it, and you think the noes had it, you should stand and call division. You can just yell division and they have to take the vote over again by rising. Next, please. Show of hands is used as an alternate for voice votes in small boards and committees. That has not worked very well virtually, but it's wonderful in person. And a counted vote may be ordered by the chair or by a majority vote of the body. And here's a place where the chair has the discretion to say, that vote is not clear, I would like to order it counted. Or the body can say, I move that this be taken by counted vote and vote majority vote. Next, please. Unanimous consent is a vote of silent agreement without any objections. The presider states, if there is no objection, the action to X will be taken. Since there is no objection, the action will be taken. We don't see this as much in local government, and I think there's a reason for that, and that is because it doesn't actually record what has been done. If there's an objection, the vote is taken, but if there's no objection, the person writing the minutes would simply say everyone was in favor. Well, if you look at the words, if there is no objection, it's not necessarily in favor. And that's why this should never be referred to as the vote was unanimous. The vote was adopted without objection. It's different from unanimous. So we don't use this as much in local government, but I will tell you, in your nonprofit, it is a gift. The minutes are presented. The chair says if there's no objection, the minutes are approved. Seeing no objection, the minutes are approved. Next, please. A ballot or roll call vote can be ordered by a majority of the body. A member has the right to change his vote up to the time the result is announced. So until the chair of the DDA says the ayes have it, any member can say, I changed my mind. I want to vote, change my vote. And that member has the right to do so. After the chair says it, the change can only be made by unanimous permission of the body. And as you can guess, depending on how the vote was going, it's very hard to get unanimous permission of the body to have somebody change their vote. Next, please. A good rule of debate. The maker of the motion is entitled to speak first. One of the reasons we have this is that parliamentary authorities, all of them, would want you to have a motion on the floor before you have any discussion. In fact, that's not how we do it in local government. We typically have a report, then questions by the body, the DDA in this case, and then some discussion, and then we have the motion put on the floor. And I think that that is what we have to do, because as Chris referenced earlier, if you come in immediately and make the motion and just roll right through, everybody will think you already met at the dewdrop in and decided how are you going to do things. So the maker of the motion is entitled to speak first, but may not, but discussion may precede that motion. A member may not speak against his own motion, but may vote against it. He may be persuaded during the discussion that his vote was not useful, that it was not a good thing, or somebody may have amended it in a way that is no longer satisfactory. And always, all remarks must be limited to the merits of the subject immediately under discussion. I'm the parliamentarian for a lot of different kinds of organizations, but I have to say, in local government, we can get off the topic and onto something else quicker than any organization I've ever seen. Next, please. All remarks must be addressed to or through the chair. If you want to look like you really know what you're doing when you're presiding, have all remarks come to and through the chair. That's really important. Personal comments about other individuals should be avoided. Members are seldom referred to by first name, that should say, rather by title. And that is true. That's just a form of courtesy to refer to people as Commissioner such and such, trustee such and such. And no member may comment adversely on any prior act of the body. So while we're having our discussion, no one should be talking about something the body did, or even a body that no longer contains any of the members who are present that they did wrong. That's useless. Next, please. I think these are two good rules. No person should speak a second time on a motion as long as another is requesting recognition to speak for a first time on the issue or motion. And here I have it under rules of public debate, but I should tell you that many municipalities for their councils have also this motion so that everybody gets a chance to speak before someone gets to speak again on the same topic. Remarks should be limited to 3 minutes. On this slide, I'm being generous. I really prefer 2 minutes. I think there's nothing you can't tell me in 2 minutes. If I give you longer than 2 minutes, you're going to tell it to me again. You test yourselves, convince yourself of something, pretend you're telling somebody else, and time yourself. The speaker may be asked but not required to state their name and any other requested identifying information. And this is a statement that if I'm doing workshops for the Michigan Association of Municipal Attorneys, they love to debate this one. Next, please. Remarks should be confined to the pending question. Again, let the people who are speaking state to their topic. Speakers should address the chair and not enter into debate with other members of the audience. And if you'd like me to reference municipalities where this happens regularly, I will do that privately. During debate, the chair shall make an effort to alternate between supporting and opposing arguments. And I think Chris gave you a good example of that when he asked who's in favor of this and who's opposed, or simply saying, referring to what the person just said and saying, is there anyone who wishes to speak on the other side? Next, please. the basics of making a motion. Someone will rise and address the chair. The presider assigns the floor by saying the name or nodding to the person. The member makes the motion by saying, I move that, or I move to. So as you're looking for the words for the chair to hear, you want to hear, I move that, or I move to. I heard several so moved. And I think it's helpful to actually say, since it's not long, instead of just when the chair says, do I hear a motion for the minutes? I think it's, instead of so moved, a person could say, I move to approve the minutes. I just think that that makes it a little clearer, especially since we're virtual, for people who are watching us to know what we just said. Then the motion maker sits down. Next, please. Motion requires a second. And by the way, the seconder can be anybody, and you don't have to be in favor. Seconder simply is a person who says, I'm willing to talk about that too. And the presider places the motion before the body saying, it is moved and seconded that the minutes be approved. Is there any discussion? Well, of course, in the minutes, you wouldn't ask the maker to speak first, but if it's a substantive motion, the maker may speak first. Members discuss the motion by rising, addressing the chair, and being called on. And in your board, if you are accustomed to raising your hands, that's fine. If you're accustomed to nodding to the chair when you wish to speak, that's fine. But in some way, the chair calls on you. Next. When there is no further discussion, or when a motion has been made to close debate, which takes a 2/3 vote, the presider takes the vote. Those in favor say aye. Those opposed say no. That's the correct, according to parliamentary law, that's the usual saying. Those in favor say aye. Those opposed say no. The presider announces the vote if it's counted, or simply whether the motion is adopted or defeated. Next, please. If the motion is adopted, the presider states how the action will be carried out. The ayes have it, and the responsible person will take action. So the ayes have it, and if this is a nonprofit, and the treasurer will send a check to the speaker as an honorarium, or whatever will happen as a result. Or the noes have it, and the motion is lost. Next, please. Well, that's a main motion. So that's how you handle a main motion. Another popular thing that we see in government are amendments. So I'll spend a few moments on those. And the object of an amendment is to change the main motion that is on the floor. And the form can be, I move to amend by inserting, I move to amend by striking out, or I move to strike out and insert. So we have a main motion on the floor to buy a bench for the park. Someone could say, and it's been seconded, stated by the chair, and we're all debating it. And someone says, I move to amend by inserting red before bench. Or someone says, I move to amend by striking out the park. Or I move to amend by striking out the park and inserting the fairgrounds. So any one of those are appropriate kinds of amendments. And next, please. And amendments are made one at a time and are intended to modify the pending motion before the pending motion itself is acted upon. So that's an important order thing to know. Think of the main motion as the big brick that's on the floor, and now you've put a smaller brick that's the amendment on top of it. You can't vote on the main motion until you take care of that little brick that's the amendment on top of it. Amendments require a second, they're debatable and amendable, and they require a majority vote. So when we have that amendment, you can go on to the next slide. When we have that amendments, oh, one more. When we have that amendment on the floor, the chair would say, the motion is to amend by inserting red before bench. Is there any discussion? All those in favor of the motion to amend by inserting red before bench, say aye. Those opposed say no. The ayes have it. And the motion before you as amended is to buy red benches for the park. Is there any further discussion? One of my favorite groups is the Wayne State Student Senate. And when we practice this, we always order a pizza. And so it gives a lot of opportunity for a lot of amendments to happen along the way. And it's a good way to practice it and to learn how to do it. And they use all of the kinds and even end up amending where they should buy it from and who's going to pay for it. Sometimes you'll hear somebody say, I'd like to make a friendly amendment. Friendly amendments are okay as long as every member of the body is in agreement with the amendment being proposed. Once we often hear someone will say, I'd like to make a friendly amendment, and a person says to the maker and the seconder, is that okay with you? That's no longer correct. Once a motion is stated by the chair, it belongs to all members, not just the maker and the seconder. And in the process of making a motion, the most important part is when the chair says it is moved and seconded to, because that puts it before you. If you're ever in a meeting where somebody says, what are we voting on anyway? The chances are the chair did not state the motion. Also, that has the effect of once it's made, seconded, and stated by the chair, that is the motion. And that's the opportunity for the maker to say, wait a minute, that's not exactly what I meant. Or the seconder to say, now that I see what you meant, I don't second it anymore. I don't think we should bother to talk about that. So think of the chair stating the motion as kind of the doorway, and the door is closed to changing it. Now we have it in front of us, but we can change it by amending. So the chair says it is moved and seconded. That's important. Now, once a motion is stated by the chair, it belongs to all the makers, not just the maker and the seconder. So friendly amendments are all right as long as the chair says, is there any objection to adding this friendly amendment that we insert metal before benches so that they're red metal benches? Is there any objection? No. Friendly amendment, it's added in. Next, please. Postpone to a definite time. To put off action on a motion on the floor to another time, day, or meeting. So I move to postpone the motion to the next meeting, or I move to postpone the motion until after the guest speaks. It requires a second, it's debatable and amendable, and needs a majority vote. And it's an awfully good motion to use when you are not in a position to make the decision right now. Next, please. Bringing a motion back again is a common question. How do we do that? Well, if you're in the same meeting, and I don't recall that your bylaws allowed reconsideration at a different time. Do you remember that, Chris? Did their bylaws say that they could reconsider at a different time than in the same meeting?
I don't recall that.
I don't think so. I don't think that's there. And really, it's probably wisely not there, because if you can reconsider a motion, then you can't take action on it until after it's accomplished. There's a community in the UP that only meets once a month and allows reconsideration for 2 months, to which I said to them, well, that means it takes a long time for something to happen. To which the gentleman said, in this rather small town, we have a lot of time. So the necessity didn't seem to be there. And I just saw one group last week, and that's why I'm not sure on which I'm remembering, where they did allow for reconsideration at the next regular meeting. The Detroit City Council allows for reconsideration for 5 days. So that, but often when you swatch them and they'll vote on a motion immediately after the motion is adopted, some other member will say, I move to waive reconsideration so that there is no hesitancy. But if it's not in the usual form, reconsider is in the same meeting or the next day. Next day is hard to do for us, as you saw when Chris reviewed the time posting is required for a meeting. Reconsider requires a second and is debatable and requires a majority vote. So a good example of reconsider is when you've done something earlier in the meeting, now you've gotten a different report and you want to change what you did. That's what reconsider is for. And you notice it has to be made by somebody who voted on the prevailing side. So you can't just keep voting on the same thing over and over again, unless somebody has said, I'm changing my opinion and I'd like to reconsider the vote. And remember, prevailing means winning. So it could even be a person, the motion could have failed and now the person wants to bring it back. Same meeting. Now, what if we didn't do it at that same meeting? Then we're up to rescind. And that's to cancel a previous action or order. I move to rescind the motion relating to red benches adopted at the previous meeting. It cannot be used when something has been done that is impossible to undo. So if the benches were purchased and placed, then it's a done deal. If they have not been purchased, have not been placed, then it's possible to rescind. Rescind requires a second, is debatable and amendable, and a 2/3 vote is required when notice is not given. And if you give notice that you're going to do it, it only requires a majority vote. Next, please. Start the meeting on time. That's always important. And I noticed you were very attentive to one time you were starting today, and that was very good. Have clear rules of procedure that are designed to encourage audience participation. Direct all comments and questions through the chair, and discourage the addition of last-minute items not already on the agenda. And that's really particular to government, because we tend to walk on things in the last minute, and that really annoys council members. So when we can avoid doing that, that's a good thing. Next, please, are the references. And here's Robert's rules. Big book, small book, good sources for information and to order anything. You might have noticed that my books are spiral bound. If you want to get your Robert's spiral bound, which of course is really handy for me because it doesn't flip closed when I'm answering questions on email. You have to buy them through the National Association of Parliamentarians. You don't have to be a member, just go to the bookstore. And the official Robert's Rules of Order website is robertsrules.com, and they're always on hand to answer questions. Thank you very much.
Thank you. Thank you both very much. I myself took a lot of notes there. There's a lot of rules I'll have to, I'm probably going to have a book purchase of it, one or multiple of those in my future. That was in
Well, and of
depth.
course you have both, and you have it recorded. So
Yes,
you know,
well,
you can have
it's
that
going to be pretty beneficial for me to be able to go back over. Thank you both again. Do we have any questions for our presenters today from any of our board members? Hearing none. I'm gonna have to work on things here. Make sure I live up to what we've been presented with. So thank you both again.
Yeah. Actually, Tyler, if I could just jump in.
Sure.
I've been in your position in other organizations of having to kind of lead these procedures. And Coco, one of the questions for you, organizations that don't have a parliamentarian sometimes get stuck when things go a little bit off the beaten track of familiar procedures. So for particularly the stuff you discussed about amendments to motions, I've been in the position of feeling a little bit stuck and on the spot, trying to navigate that as a meeting chair. And I imagine Tyler will find himself potentially in that situation. But for all of us, are there, I did a quick search of like Robert's rules, flow charts, or one pagers or cheat sheets. And of course, those exist. But do you have any recommendations for how an organization like ours, without a parliamentarian, can best navigate between fidelity to Robert's rules, which is not 100% achievable probably, versus expedience and getting stuff done? Like how?
First of all, here's my favorite one pager, which I will make sure that your staff knows how to order them. Basic information, everything you ever needed to know, right here. Now, including on how to amend. But really, the best thing to do is slide 8, which is basic objectives of parliamentary law. Just look at that. Is this going to accomplish what we want? Is this going to expedite business? Is this fair to everybody? Will this maintain order? And never hesitate as a chair to pause and say, this is how I think we should handle this. Is there any objection? Seeing none, this is what we will do. There are, much to your amazement, there are two national organizations of parliamentarians. And I just watched the American Institute of Parliamentarians National Convention with their very, very skilled chair, who at one point said, I'm going to need to think about that a minute. Can you just give me a moment, just stand in place? And he came back and he said, how's this sound to you? Any objections? And we moved forward. So I think that, does that show that the chair's unsure? No, it shows that the chair really, really wants to get it right. So, but I will make sure that we get all this to all of you.
Thanks, Jonathan. That's a great follow-up, and I appreciate you, Coco. This is all incredibly useful. Maura, I know, will be helpful in pursuing sort of our follow-up to make sure we have the documents we want. I know I will personally follow up with you, Maura, just to make sure I have the proper tools at hand. I believe that's the end of the presentations. Again, thank you both. And we will move forward with the agenda.
Tyler, I have my hand up, but I don't know if you can see it.
Oh,
Maura,
so
sorry.
This is my color blindness. Sometimes things blend in, I think. So I miss it, but go ahead, Maura.
Well, Jonathan's question is a great segue for a comment I wanted to make. I wish I could have had a sidebar with Coco at the start of the meeting, because when I did roll call, I realized that we actually don't have a quorum, and I take responsibility for not pointing that out. So I believe that our July minutes that were approved at this meeting will have to come back to the October meeting. So I don't think we've done a whole lot of damage, but I just wanted to acknowledge, and yeah, I would love to have Coco at every meeting if that's possible.
I was going to take that up with you privately. I realized as the roll was called that you did not have a quorum.
And we felt like it should be acknowledged publicly.
Yes, and you're absolutely right. The minutes simply go over to the next meeting and are dealt with along with the minutes for, and this, in my rules, Coco's rules, you would make a record of this meeting. That you would effectively have minutes of this meeting, noting that there was not a quorum present, but noting who was there and what occurred. Because if you have a requirement for your organization that you have 10 meetings a year, even if one of them doesn't have a quorum, you still had 10, and you can count it as long as you made minutes of it. Little known fact.
Great tip. Thank you.
And remember, when you take the minutes and you have more than one set, vote on them individually.
Thank you very much.
Yeah, thank you again. This is incredibly useful, especially for me going forward. Do we have any other questions, comments before we move ahead to public comment? Seeing none, we'll move ahead. Thank you both again.
Thank you.
Kelly, you can help me out here. Are there any members of the public who wish to address the DDA board?
I do see some of the public in attendance. I don't see any hands raised. We'll give them a moment. Yeah, I don't see anyone raising their hand, Tyler.
Okay, so we do not have public comment. The next board meeting will be on Wednesday, October 6th of 2021. We have another member of the public joining.
Yeah, do we want to wait a moment?
Yeah, should we wait just one more moment here? If we have any members of the public that wish to speak, feel free to raise your hand. All right. Well, seeing none, the next board meeting will be on Wednesday, October 6th of 2021. I'd like to ask for a motion and a second to adjourn the meeting, and paying attention to what we just learned. When you move, please say, "I move to adjourn the meeting."
Tyler, this is Alex. I move to adjourn the meeting.
Do we have a second?
This is Jihae, seconded.
All those in favor say aye.
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 All those opposed, please say no. Thank you, and the meeting is adjourned.
Thank you.